A federal high court sitting in Abuja has issued an order compelling former President Goodluck Jonathan to appear before the court on Wednesday, October the 25th. The presiding judge, Justice Okon Abang, issued an order for the former president to appear as a defense witness in a suit filed by the federal government against Olisa Metu, a former PDP National Publicity Secretary. Mr. Metu is facing trial for allegedly receiving 400 million naira out of the $2.1 billion arms fund from the former National Security Advisor, Sambo Dasuki. On Monday, lawyers to Mr. Metu asked the Federal High Court in Abuja to compel Dr. Jonathan to appear in court as a defense witness.
It is the continuation of the trial of Mr. Olisa Metu. Proceedings begin with the lawyer Ahmed Raji representing the former National Security Advisor Colonel Sambo Dasuki, arguing his application seeking to set aside the order of the court compelling his client to appear as a defense witness for Mr. Metu. The prosecutor and the defense lawyers, however, opposed the application on the grounds that Colonel Dasuki is not a party in the suit and therefore cannot challenge the order of the court compelling him to appear on Wednesday, the 25th of October, 2017. After listening to arguments for and against the application by the lawyer to Colonel Dasuki, Justice Abang reserves his ruling until Wednesday, the 25th of October, and insists that the earlier order of the court compelling Colonel Dasuki to appear before it still subsists. But the lawyer to Colonel Dasuki appears unhappy with the position of the court.
For somebody who has been deprived of his liberty for almost 2 years, and for somebody who has been indicted in the same charge, it is very oppressive to have him compelled to come and give evidence.
In addition, the court orders former President Goodluck Jonathan to appear before it also on Wednesday, the 25th of October. The registrar of the court informs parties that the former president is yet to be served with the order of the court. Lawyer to Mr. Metu and the prosecutor share a similar perspective.
A subpoena is supposed to be an order issued by the courts to compel a witness, in this case His Excellency, to appear and give evidence.
Their lordships of the Court of Appeal were very emphatic that under the law, once a witness is served with a subpoena, is under a duty to answer to the command of the sovereign state.
Whether or not the former president will appear in court on Wednesday, the 25th of October, will, however, be dependent on the court bailiff serving the order on him before the end of Tuesday, the 24th of October.
After sitting in the north, the south-south and the southeast, the presidential panel of investigation set up by the Vice President, Professor Yemi Osinbajo, to review compliance of the armed forces with human rights obligations and rules of engagement has officially begun sitting at the Lagos High Court Ikeja to hear petitions for the Southwest Zone. The panel, which was inaugurated on August the 11th, is headed by a Justice of the Court of Appeal, Honorable Justice Abraham Georgewell. Today, the panel listened to parties who've submitted before it petitions of alleged human rights abuses by the armed forces in the course of managing and containing local conflicts and insurgency in the country. The panel hopes to submit its report in the next 3 weeks.
We started our session yesterday in Lagos for the Southwest Zone. At the conclusion of the sittings in Lagos, we will have rounded up our public hearing. But because there are still so many fallout from the sittings, we are going to have a rounding up sitting in Abuja from the 30th of October to 2nd of November, by which time we'll wind down sittings and then we'll go into our deliberations. And we hope that in the next 3 weeks, we should be able to be through with the deliberations so that we can be able to forward our recommendations to the federal government for its consideration.
All right, let's cross over to Abuja, and here's Gloria Umezoke. Gloria.
Hello, Ejoma. Ahead of the December 2017 National Convention of the People's Democratic Party, PDP, both the chairman of the PDP Board of Trustees and that of the Caretaker Committee have warned chairmanship aspirants to desist from actions that are capable of plunging the party into another round of leadership tussle. The two men were speaking at the 76th National Executive Council meeting of the party in Abuja. The PDP would be holding its national convention in December to elect principal officers of the party after an attempt to hold an elective position in Port Harcourt failed last year.
It is less than 7 weeks to the proposed national convention of the People's Democratic Party, PDP, and preparations appear to be in top gear as the leadership of the party at various levels meet with aspirants to ensure that the convention is successful. At this 76th National Executive Council meeting of the PDP, concerns about the success or otherwise of the party's convention also took a center stage, as leaders of the party warn aspirants against actions that are capable of plunging the party into another round of leadership tussle.
We must be careful while pursuing an interest. We don't pursue it to the extent that we create a dangerous precedent that somebody power hungry can use it tomorrow to unleash some other kind of issue.
There is need for proper homework and care before the convention. We must work together to produce trustworthy, humble, dedicated officers. The success of our convention will depend on our unity and love for this party.
The chairman of the PDP Caretaker Committee heard earlier in the day met with all chairmanship aspirants with the same message. While the emphasis appears to be on the need for aspirants to put the interest of the party ahead of self, the Deputy Senate President also cautioned the party against impunity.
The forthcoming convention will be a lasting legacy they will leave for our party. So I'd like to use the opportunity to implore them to do everything possible to ensure transparency, to ensure justice, to make sure there's equity and that it is trouble-free.
The proposed December 9 convention is the second attempt to elect principal officers of the PDP after a first attempt to do so during the Port Harcourt convention failed last year.
Well, meanwhile, ahead of the November 18th governorship election in Anambra State, the chairman of the Independent National Electoral Commission, INEC, Professor Mahmoud Yakubu, has raised concern over unlawful substitution of candidates by some political parties. The INEC chairman, who spoke at a meeting with members of the civil society organizations in Abuja, explained that two prominent political parties have substituted the names of their candidates who participated in the primaries with new candidates who never participated in the primaries. According to him, while the electoral umpire has no legal rights to reject those substitutions, the actions of those political parties could have some negative effects on the elections.
37 political parties are contesting in the Anambra election, which is a record. It's a record for any governorship election in the history of this country. 37. They all conducted their primaries. We monitored the primaries, but I also wish to draw the attention of civil society to the action of two political parties. I wouldn't mention the names here. I mentioned it when we met with the political parties about 2 weeks ago. We monitor the party primaries. We know those who emerged as candidates from the primaries. But somehow, somewhere between Oka and Abuja, two parties substituted the candidates. The names that they finally submitted to the commission are not the names of candidates that emerged from the party primaries which we monitored. Again, the Electoral Act says that if that is done, INEC has no power to disqualify any candidate nominated by his or her party. But 35 political parties are in compliance. What transpired at the primaries is what was actually transmitted to INEC. But two political parties changed the candidates. Those who emerged from the primaries are actually not the candidates whose names were eventually submitted to INEC. But we said that if any of these candidates wins or the matter is challenged in court, will go to the court and present the true record of what transpired at the primaries for the courts to determine what to do. We will never defend what we cannot defend. We will never defend anything that did not correctly transpire at the party primaries.
A controversy is brewing ahead of the local government elections slated for February 2018 in Rivers State, following the alarm raised by the caretaker committee chairman of the 23 local government areas in the state over what they describe as the abuse of court processes. The chairmen are calling on the Chief Justice of Nigeria and the National Judicial Council to intervene in the matter, which, according to them, is an attempt by the opposition party in the state to scuttle the process through the back door. The PDP chairman believe that a Court of Appeal panel set to sit in the state capital on Wednesday is acting against judicial order to hear a matter that is already at the Supreme Court.
The 20th day of June 2016, the Court of Appeal granted some members of the All Progressive Congress leave to appeal against the ruling of the Federal High Court, which set aside the purported election. These persons were neither parties to the original suit, nor were they candidates or winners of any election at the time the original summons was commenced by the PDP at the Federal High Court. Being aggrieved by this decision, the government of Rivers State, as parties to the appeal, challenged at the Supreme Court, and that appeal was entered in the Supreme Court on the 4th of July 2016.
There is no matter in the Supreme Court. The matter is here in the Court of Appeal. They have brought several motions. The last time we were in court, they had brought a stay of proceedings pending when they will have the stay of proceedings granted at the Supreme Court. They have not obtained that the Supreme Court will, grant them a stay of proceedings for this matter not to go on. That has not been granted the PDP.